My name is Alan Chang. I'm a licensed lawyer in Ontario. I currently practice family law, litigation, and immigration law, and I'm currently with the firm Saw Law Professional Corporation. Before I begin, I would just like to put out a disclaimer that today's video is for informational purposes and should not be construed as legal advice. There are typically 4 types of agreements, which is the marriage contract, the cohabitation agreement, the separation agreement, and as well as the paternity agreement. And for today, I'm only going to focus on 3 of them, which is the marriage contract, cohabitation agreement, and separation agreement. The first one, we're discussing the marriage contract, and this is also commonly known as the prenuptial agreement, which is also a form of marriage contract, and it's not the only kind of marriage contract. As one knows, the prenuptial agreement is one that is entered before the party's marriage. For what goes into a prenuptial agreement, it actually can contain more than you would think. You can actually put in stuff on division of property, legal protection of the children, obligations of spousal support, as well as marital responsibility. First of all, I'm actually going to go into the 2 big ones, starting with the division of property and ownership. Regarding division of property, in Ontario, when a married party gets divorced and it goes into a family proceeding, there's something the court asks the parties to do, which is to do an equalization of net family property. This is essentially where the parties will list out each of their assets and debts, and then the courts are going to compare of their assets and debts at the start of the marriage and at separation. And then in contemplation of this, the parties can agree to contract how they want to divide their property prior to marriage. And for division of property, this does not include the matrimonial home. The matrimonial home is an exception in Ontario, which I will get into in a later video. But the division of property can go for any other family property or personal property, for example, like investment property. For example, if one of you were to bring in an investment property prior to the marriage or owns investment property prior to the marriage, you can agree on that this property will remain yours even after the marriage without having to split the gains of it during the marriage. This is something that both parties can contract prior to their marriage. So for the legal protection for children, this one I think a lot of people actually do not consider when doing their prenuptial agreement, as this does not have to do with custody actually, or who's going to take care of the children for how long after the relationship has broken down. Right. This is actually agreement on how you are going to raise your kids during your marriage. This is something I think typically most people do discuss with their partners, but never really put into words as into a marriage contract. I think it is an important thing for 2 spouses, 2 partners to discuss honestly prior to marriage on how they're going to raise their children. And just by putting it into words, it does show to you and your partner an intent on how you plan to raise the children, as well as it will show the court in the future as well of your intent at the time. As to what people would put in regarding the legal protection of the children, it would be, one would be how much money that each of you plan to contribute to the children's expenses, whether it can be to their education or to extracurricular activities. And another very important point would also be religious or cultural practices, as well as any beliefs or values that you plan to instill to them. For some, they may even have an agreement on what school for the child to study at, whether it is in their own school district or maybe to put the child into private school, as all of these are very significant decisions for the child, as well as significant financial decisions for the spouses. You do not need to consider the legal protection of children for it to be a valid prenuptial agreement. So this part is purely optional on whether or not to include it as your prenuptial agreement. But I believe that these are definitely good topics for you and your partner to talk about going into marriage. Now, of course, as you mentioned, situations do change, and with the prenup agreement, especially with, let's just say, how much one plans to contribute. So if it is no longer viable, the parties can discuss and make another agreement during their marriage as well. So a prenup agreement does not mean that you are going to be bound to life for this in your marriage. Oh, okay. You can still, always amend it, discuss it, especially with something like the legal protection for children or for these financial circumstances. As you develop or as the marriage grows through the years, there are definitely going to be changes, and I'm sure there will be further discussions with your spouse on, what changes to make or what agreements that you may have, once you have children, or maybe you choose not to have children. So, this is something that can be a developing thing. Prenup agreement is not mandatory, as you would know, some people choose to enter to one. as a way, to protect themselves. I think a way to consider a prenup agreement is not really, you don't want to think it as, if you were the one asking for a prenup agreement, you're only asking to protect yourself. Prenup agreement is a contract between both of you. Mm-hmm. So you who are, if someone proposes to have a prenup agreement, you can also propose your own terms. You can find something that is fair for you as well, and so you are not just bound to what one party says, essentially. So then a prenup agreement, it really needs to be considered more as a contract where both parties are negotiating for what they feel is fair and right for them. And with regards to spousal support, this is an issue that does come up quite often, especially it's very common where, one partner goes to work and the other may, if they have children, will have to stay home and take care of the children. And contemplating this, just in the unfortunate event where you do have to separate, it's nice to have the protection for the parents staying home to know that, they will still have some spousal support even after the marriage has broken down. Regarding who's going to stay at home with the children, how are you going to spend your money or obtaining credit, as well as, who will be doing the bills, filing the taxes on behalf of the family, and as well how to handle your personal and joint bank accounts. These are all intricately tied with, the partners, with you and your partner's everyday lives. Prenuptial agreement, it does have a bad connotation where people associate with, you're already contemplating on breaking up even before actual marriage. For this one, like I mentioned, honestly, these are guidelines for conversations that you should have with your partner going into this marriage. And that's it. Often people do not put this into a prenuptial agreement. Right. It is ones you can definitely put in and contemplate. But these are definitely stuff to have a healthy discussion with your partners about. If this is especially coming from a second marriage, or if you already have to bring children into this marriage, right. These are all very important conversations and topics you really want to establish ahead of time, and you don't want to get into, big arguments during the marriage, as they do deal with very important issues such as education, religious, cultural practices, which can cause a lot of conflict if these were not discussed ahead of time. So for a marriage contract, the prenuptial agreement is a type of marriage contract already. So a marriage contract can also encompass the contracts that you made in the marriage. As we discussed, your life changes, you could change your job, you maybe come into some money, you buy investment property. But a marriage contract is essentially a contract dealing with these issues, but that are contemplated during the time of your marriage. So they are definitely in anticipation in case that you do separate, for the future. But then for a marriage contract, they are essentially like a prenuptial one, but they are made within a marriage as well. Cohabitation agreement, that would be for when the couple have not married. So they have not officially get their marriage license and certificate, and they are in a relationship and that are living together. The court and the government recognize the marriage as an economic partnership, so there are certain benefits and rights of having the marriage comparing to a couple who are in a common law relationship by only living together. For a common law relationship, there is no matrimonial home. Yeah, so that is actually a very big one, and typically this is the one that does come up the most often, as typically the matrimonial home is a couple's largest asset for most people as well. When you are in a common law relationship, you're not protected by the matrimonial home. And the matrimonial home, I'll just briefly discuss it now, is essentially it is the property where you and your partner lives in, and is considered the family home. The matrimonial home is outside of the net family property. It's not discounted as part of the net family property in the sense that your spouse would have 50% or equal rights to it as you. It doesn't matter whose name is on title or who purchased the property as well. Regarding a matrimonial home, we can delve into details about it later on in our next segment. So regarding the economic benefits of marriage, as we was mentioning earlier, there is no such protection for common law partners. So a cohabitation agreement help protecting, people who are living together in a relationship, because essentially if you separate, there is limited claims that you can make. In a common law relationship, if you want to recover monetarily, it is based on an equitable right. So it is if the other side has been unjustly enriched. And for unjust enrichment, for example, if you were living in your partner's home, say for example your partner is the one that has the property in his or her name, but then in your relationship, say a 10-year relationship, you've been making all the mortgage payments for that property. So after 10 years, after you separate, if you have been carrying the burden of all the mortgage payments, it would not be fair to say that you get nothing. So essentially, then you can bring an equitable claim of unjust enrichment, saying that, you should at least recover monetarily, recover something from being in this relationship, what you have put in, where else the other side would have been unjustly enriched. Cohabitation agreement deals with the issue ahead of time. You can agree to decide how you want to split these payments, or how you're going to deal with property that both of you have been living in as well, without having to go to court at later time. If you end the relationship in a common law relationship, then you don't automatically get anything. Even if after all these years you've been putting in, like the mortgage, the bill, or utility, you essentially need to be asking for that back through equitable remedies, as we mentioned, like through unjust enrichment. Separation agreement comes in when the parties have decided that the relationship is over and that the parties are separating and are contemplating on how to deal with corollary issues involved with divorce. As we mentioned, these issues would involve the financial aspects, so there is property division, the children as well. Furthermore, regarding the financial aspect, more than just property, there's also personal assets and debts as well to be considered. Spousal support as well, child support, parenting time, decision making. For a separation agreement, it depends on what your marriage was like. And as we mentioned before, if you did not have any property issues, if you don't own any property, no one's going to dispute it. And if you don't have any children, then you're well along to, you can just go ahead and proceed with a simple application, or what's what we call the uncontested divorce. But when you have property where the other side is going to dispute about, or if there's issues with the children, and largely it is the children. If you have children and if you do not resolve these issues, a judge is not going to grant your divorce. When you do your joint application for divorce, to say you amicably did resolve all the issues, the judge needs to know what you agreed on. That's why we got to put it down in writing. The judge can review it. If he's satisfied with it, he can sign off on it. You cannot just go to a judge saying, okay, we agreed on everything and that's it. Like, you don't tell the judge what it is. It's a joint application. It can just be done by paper. So if a judge can, review your separate agreement, he's satisfied, and it's good.